Hi, I'm Chris Hildebrand at Hildebrand Law, and I want to talk to you today about how retirement accounts are divided in a divorce in Arizona. I want to start our discussion with the Arizona Supreme Court case of Van Loan versus Van Loan. Now, the Arizona Supreme Court in the Van Loan versus Van Loan case had to answer the question of whether an unvested pension constituted community property in Arizona. The court concluded that retirement assets, including pensions, are treated in the same manner as all other community property in Arizona and are therefore divided between the spouses in a divorce. The court will apportion the community property interest in retirement accounts between the spouses and will award each spouse his or her separate property portion of those retirement accounts, such as some of the retirement account that has been accumulated prior to the parties' marriage. So I want you to understand there are several ways to determine the community and separate property interests in a retirement account. The approach used depends on the type of retirement account to be divided. Retirement accounts are either a defined contribution plan or a defined benefit plan. So let's start our discussion with defining a defined contribution retirement plan. A defined contribution retirement plan is a plan where you invest money that grows over time, like an IRA or a 401k. You're only entitled to the value of what's in that account. A defined benefit plan, on the other hand, is a plan where you may or may not invest money into the plan and you'll receive a monthly amount at a certain age, like a pension. You may or may not be entitled to the value of the account in lieu of or in addition to monthly pension payments, depending upon your plan. Now, the Supreme Court in the case of Johnson versus Johnson presented an excellent analysis of how retirement accounts are divided in a divorce in Arizona. Specifically, the Arizona Supreme Court in the Johnson case established the ways a court may determine the community and separate property interest in these types of retirement accounts. The actual division of the retirement account occurs by rolling out an amount into a separate account for the spouse receiving an interest in the retirement account. Alternatively, you can offset that spouse's interest in the other spouse's retirement account by awarding him or more of other assets. Now, if you're dividing a retirement account, you may need to prepare a special order referred to as a qualified domestic relations order, or in some cases, simply a domestic relations order. That is an order that directs the plan administrator of the retirement account as to how to divide the community property portion of that retirement account. Military retirement pay may also be divided in an Arizona divorce. However, special circumstances exist in certain cases of military benefits, such as combat-related special compensation payments and other forms of military disability payments that may not be divided in an Arizona divorce. However, the Arizona Supreme Court in the unpublished case of Merrill versus Merrill held that a trial court might order a spouse to compensate his or her spouse if the court previously awarded the division of military retirement pay that is subsequently turned into combat-related special compensation pay due to the subsequent disability of the military spouse. Since Merrill is an unpublished case, you are not permitted in most cases to cite the case's authority to the court. If you have questions about dividing a retirement account in an Arizona divorce, we hope you call Hildebrand Law PC. Our Arizona community property attorneys have over 100 years of combined experience successfully representing clients in divorce cases in Arizona.